Okay, good morning and good afternoon to some. Welcome to the roundtable on the theory and practice of prevention in international law. My name is MJ Durkee, and I'm a professor of law at Washington University in St. Louis. And we have a great group of speakers here today, and we're happy to help all of you in the audience as well. And this is being recorded for future viewing. So the full title of this panel is Prevention as an Object and Strategy in the Standards and Policies of International Organizations. And it's a project of the American Society of International Law's International Organizations Interest Group, which is headed by Duncan Picard, Leslie DeClercq, and Christian Jimenez Corte. So that group is launching a multi-year study of the role of international organizations in the international rule of law. And if you're curious about that project, you can reach out to any of the IO's leaders, Duncan, Desiree, or Christian. So this event is also co-sponsored by the International Legal Theory Interest Group, which I'm currently chairing. So now, before we get started, let me introduce our speakers we have here today. We have Shala Ali, who's a professor of law and associate dean at the University of Hong Kong Faculty of Law, and she directs the LLM program in arbitration and dispute resolution. Her work centers on questions of governance, sustainable development, and cross-border dispute resolution in the Asia-Pacific region. She serves as a bilingual arbitrator with multiple arbitration centers and has been engaged with dispute resolution reform at the regional and global levels. Fiona Mongan is a senior fellow with UN University's Center for Policy Research. She served as an expert with the panel of experts on the Central African Republic and the Democratic Republic of Congo, monitoring UN sanctions regimes and reporting on compliance and potential violations to the UN Security Council. And her previous roles include with the United States Institute of Peace, Justice and Security and Transitions, the Stimson Center, and the Irish Department of Justice, among others. Remy Moncel is senior counsel in the World Bank's legal vice presidency and has been working at the intersection of law, development, business, and sustainability for over 15 years. He's currently a member of the World Bank's Environmental and International Law Unit and previously practiced law at O'Melveny & Myers and at the international environmental think tank World Resources Institute. And last but not least, Wes Rist is an atrocity prevention policy advisor, a contractor in the State Department. He's in the Bureau of Conflict and Stabilization Operations. And he previously served for over 10 years at the American Society of International Law as the Deputy Executive Director and Director of Education and Research. And he has also advised the US government for over 10 years on genocide and atrocity prevention issues as a member of the Prevention and Protection Working Group. So we have a great group here, a balanced group of practitioners, academics, governmental advisors. The roundtable is and I should say at the outset that they're all speaking on their own behalf and not for any institutions which they might otherwise represent. So this roundtable is addressing prevention as a concept in the theory and practice of international law, right? So many international legal obligations have been developed to try to prevent various types of harms to people and environments. And there's a whole range of examples. There's a few that are in the concept note for this panel. The UN Convention on the Law of Sea prevents pollution of the marine environment. Human rights treaties prevent violations of substantive obligations. Development banks prevent harm to communities, and the list goes on. So it is a principal aim of wide swaths of international law to prevent various kinds of harm. But even though this is really self-evidently true at a conceptual level, this way of thinking about international law has not been a dominant theme in international legal research and discussion. Instead, international lawyers and international relations theorists have really focused on theories about the nature of international law, its bindingness or non-bindingness, theories of compliance, among other matters. So what about theories of prevention? It would be good to know when international law is most effective at preventing harms. What are the legal and governance tools available to prevent harms? And what about the everyday practices of lawyers and other officials in preventing and their focus on preventing in international organizations and bodies. So clearly this is too much for a 1-hour panel. So the point of our discussion today is really to open up these questions and hopefully to inspire more conversations about this topic. So let's start. Well, so I also want to mention that for those of you who are here watching the webinar, please do present your questions that you might have about this topic or things that might arise along the way. You can use the Q&A function in the box below, and we will try to preserve some time for questions during the discussion, especially at the end. So let's start with a brief overview from each of the speakers about what prevention means from the perspective of your various fields and areas of expertise. So for example, what are the kinds of harms your field seeks to prevent? What is the conversation about prevention in your field? How does your field frame or define prevention? Get us started in thinking about prevention from the lenses that you've been using. So let's start with Shala Ali.
Great. Well, thank you so much, MJ. It's great to be here and with colleagues on this panel. So recently, and I guess over the last, say, 10, 15 years, I've been looking at the field of law and development, law and infrastructure development in particular. And I think that's an area that has been growing. And so in terms of the harm that it seeks to prevent, in terms of how prevention is conceived, it's really, as you mentioned in the opening, community harm is really the key area, as well as environmental harm. So I think those are the two key harms that it seeks to prevent. I think in general, outside of this recent discourse, I think historically the idea of prevention has been more framed in terms of mitigation, with the assumption that we're trying to reduce severity or seriousness, but somehow harm is inevitable. I think over time that's shifted towards recognizing that with the right structures in place, certain harms aren't inevitable, that with the right kinds of consultation mechanisms and screening mechanisms for the types of infrastructure that's supported, these harms can be prevented more effectively.
Great. Remy, what are your thoughts?
Thanks, MJ, and good to be with all of you. So the World Bank, approaches the issue of prevention from a variety of standpoints, and I'm just going to speak about one narrow aspect of it. But you can think of prevention around avoidance of escalation of conflicts in fragile regions in which the World Bank might operate. You could think of preventing corruption in World Bank operations. I'm not focused on those today. I'm focusing narrowly on the issue of preventing environmental and social harm that might arise from the impacts of World Bank financed projects. These are projects that borrower countries of the World Bank seek financing from the World Bank for around infrastructure, around education, around health, a number of other issues. And in the context of those projects, there can be adverse impacts that result from those projects that are being financed. And that's the area that my unit focuses on, and the World Bank has a policy that governs the avoidance, to the extent possible, of those harms. It's called the Environmental and Social Framework. And it's really focused on 10 standards that range from labor related harms and protections to community health and safety, biodiversity protection, protections for indigenous peoples, issues around land acquisition and displacement, community consultations. So I'm happy to elaborate on those, but that's really the focus of my work, and a big part, I think, of the work of multilateral development banks. The World Bank has its own framework, and other MDBs have their own frameworks that are similar in some respects to that of the World Bank. I think of prevention as a composed of three main elements. One is a focus on due diligence at the project design, appraisal, and implementation stage. So you want to try to avoid harm to the extent possible. Second is an emphasis on information disclosure and civil society consultations. I think that's critical in order to have a good understanding of what the impacts of a project might be and what those impacts are when they materialize. And then third is an opportunity to raise grievances. So allowing civil society groups, government stakeholders, the private sector, others, development partners in the country or elsewhere to bring to the attention of the government or the World Bank or the other international financial institution their awareness of harms that have occurred and seek redress for those harms. So those are the three components that the World Bank's policy and our work every day focus on. I'm happy to go into those in more detail.
So this is interesting. We've already seen a gap opening up between these two areas where in the context of the World Bank's work, prevention has been a theme that's so strongly emphasized that you have a whole infrastructure developed around it for thinking about prevention and working on it. Whereas Shala, I heard you talk about how this is we've come to prevention a bit later and a more recent shift in focus from the idea of this inevitability of harms to a prevention framework. So that's interesting. So let's hear from Fiona and then Wes about things from your side of the world.
Yeah, so my world is revolving around, this whole system of UN sanctions, and the imposition of UN sanctions is meant really to be a last resort when it comes to addressing very serious human rights violations, humanitarian law violations, curbing illegal smuggling, stopping behaviors of extremist groups. And I think recently we've really seen sanctions being used in the UN framework to support broader UN peace efforts, so seeking to reduce the power and influence of spoilers by sanctioning individuals or entities who engage in activities that undermine peace processes, including armed groups and their leaders. And so prevention, of course, lies very much at the core of this. And the ideal being that by putting in place a sanctions regime, you may, for example, with an arms embargo, prevent the rearming of an armed group, therefore preventing or potentially mitigating, as Shala said, or reducing their ability to re-engage in violent conflict. Or indeed, it could be that you're placing restrictions on a member state government and how they're able to acquire weapons and ammunition for their security sector until such a point as they can demonstrate that their military and security sector actors do not engage in predation on civilian populations, or that they have sufficient weapons and ammunition management systems in place to ensure that the diversion from their stocks is not a key source of weapons that continue the cycle of conflict, or by placing an asset freeze or a travel ban on key individuals or entities in order to reduce their capacity to engage in activities which undermine efforts to restore peace or stability, or indeed just using the threat of those sanctions to deter groups from committing violations of international humanitarian law or human rights law. And so the fundamental question, I suppose, in my field, and really a global question, is whether these UN sanctions regimes have an impact in terms of prevention. Unfortunately, the answer is not straightforward. As a former member of the panels of experts who investigate and report on the implementation of those sanctions regime and possible sanctions violations, I would say I've seen both sides of the coin. I've seen instances where you see some preventive impact, even indirectly, and others where blatant and systematic violations occur and continue to occur. And so I suppose just to spotlight one important conversation that is ongoing currently in my field and amongst member states, sanctions watchers, panel of experts members, I think there's a real question as to whether the space and the appropriate protections exist in order to allow panels to work and to truly carry out independent investigations, or whether the reality of political pressures, which have always been an issue, of course, are just becoming too much of a factor. So in recent years, we've seen significant increase of threats to panel members in conducting their work. An individual arrested and detained by a member state for a significant period of time while carrying out his work. 2 panel members who were tragically killed in the Democratic Republic of Congo while they were carrying out a very sensitive investigation. Threats to panel members from member states, from their security sector actors, surveillance concerns and cyber threats, and increasingly, and I think this is a very key issue, a very political issue, issues in relation simply to the appointment of experts. So Security Council members can place a hold on the appointment of experts, and recently we saw a series of panels placed on long holds, and then one, the Central African Republic panel, vetoed entirely and asked for a full replacement of the slate. And so what this does in a practical sense is it paralyzes the work of the panels. So violations continue, but without documentation. And just from a practical level, without the documentation, do you have the same preventive impact? And so, you know, I think with a lot of questions ongoing about whether multilateralism is under threat, is it any wonder then that, you know, there are questions about the preventive efficacy of a very crucial multilateral tool such as UN sanctions.
Great, thank you. Wes.
Sure, and for context, the prevention angle that I work in is related specifically to mass atrocities, war crimes, genocide, crimes against humanity, ethnic cleansing issues. And it springs from a international legal obligation under the Genocide Convention, that Article 2 says, you know, prevention of genocide is a critical part of the international law community's responsibility and the international community of nation states. The reality is no one engaged with that as a lens of thinking about international law or about state obligation for 60 years. Until the late 90s at the earliest, in terms of what people were thinking about, you know, in terms of doing actual prevention. And I think in many ways, international law in this area developed along the, you know, idea of prescriptive and punitive approaches, not preventative approaches to these issues, and relied quite heavily on the community of global actors kind of all agreeing we should not do this, and if we do it, someone will be punished on the back end. And therefore, we don't need to invest in prevention. We don't need to think about actually heading these things off, making sure that they do not occur. You know, reality is such that even during the Cold War and the post-Cold War, immediate post-Cold War time, clearly that wasn't working. Like that just wasn't actually a viable option for these issues. But it was still politically feasible to ignore it. And I think the introduction of greater communications technology, post-colonialism, really expanding and being an important part of the international conversation, all of those things changed the reality of what was acceptable in terms of the harm and the risk of harm that could be kind of abided by. Under the Obama administration, the State Department stood up the Atrocity Prevention Board, which was the first time that I'm aware of that a state kind of said, we actually think that we should stop these things before they happen. But it was an entirely executive branch approach. It could have been knocked out, and we saw dips in its effectiveness as personalities that drove it moved on to different things, and there wasn't the same sense of political will or power to engage with them. And what changed in the US at least was, and I was part of this civil society community that worked on this, was the passage of the Elie Wiesel Act that took 5 years to get passed. It was not oh, this is a good idea, let's do it. It took effort over time to get people to buy into this. But once it did, it established a mandatory institutionalization of atrocity prevention within the US government framework. In the early 2000s, or I guess late early 2000s, we also saw the introduction of the UN Office of Genocide Prevention and the Responsibility to Protect as well, which was an attempt to do this at the international level. Has a different model and approach of prevention than the US government is pursuing on that. But both of them have turned to things like analytical assessments that address risk factors and use law and policy. And I think this is an important part. Like there is no achieving of prevention without policy coming alongside the law here. Like international law is not going to do this through passing treaties and conventions. There's got to be a collaborative approach here between lawyers and the policymakers and decision makers. And so we saw that, you know, come into effect and move the conversation forward on this. And now, and Remy's point was something that I appreciated greatly in terms of the steps they go through of consultation. Like part of my job as an atrocity prevention policy advisor is engagement with civil society, local actors, indigenous communities, at-risk communities. Like it is impossible to do this job unless you are talking to the people who are experiencing or are at risk of the effects that you are trying to prevent. So much of this field, I'm not speaking for the others, is incredibly context specific. Things that might be warning signs of real atrocities in one country might just be people being rude to each other in another country. Like, you have to understand the underlying cultural and social norms that are being either enforced or violated. And so that civil society consultation is an incredibly important point, which is another area that international law struggles with. It's designed for states at this level. It struggles to figure out how to bring in non-state actors, and yet that's essential in my field for moving the ball forward.
Great. Oh, so it's interesting that one thread that seems to have come through all four of these answers is that there's some knowledge or data that's needed to be able for law to take a preventative posture. So perhaps this a focus on prevention might be kind of going along hand in hand with a technocratic, policy-oriented, a data-driven kind of turn in international law. Wes, you talked about trying to understand risk factors. Fiona, you talked about trying to figure out what kinds of sanctions will defang some potential harm, or some groups' capacity to inflict harm. Shahala, you talked about screening mechanisms. Remy, you talked about due diligence and information gathering. All of these things, we're out of this heady international relations territory where we're thinking about state-to-state negotiations, and now we're thinking about data on the ground, like how can we use international legal tools like sanctions or other things to respond in a more data-driven way. And so I guess I would invite reactions to this. What are the tools? Do you agree with this assessment, and what are the kinds of tools you think that are used in your area to accomplish prevention? I was thinking more in terms of hard law, soft law, institutional, and so forth. But what I'm hearing instead is really about data, and maybe this is somewhere where some of the new data capabilities might help us as well. So could you comment on that?
Yeah, I can jump in on that one real quick, MJ, because I think it really is critical, this data piece of it. Our legal approaches and our policy approaches have to be informed by data in my particular field, because it is so context specific, and because we do rely on understanding the issues that are in play in particular countries or even subnational regions. Like, you can't even approach some of my issues, you can't approach them from a country-based perspective, because what's happening in the North is going to be different than the South, or what's happening with this community from that. So we have my bureau, the Bureau of Conflict and Stabilization Operations, has this wonderful group of people who are a blend of policy experts and data scientists, our Office of Advanced Analytics. And what they do, and our bureau motto is anticipate, prevent, and respond. And what they do is try to look for trend lines, for indicators, for data-driven analytical approaches that they can package into tools that non-data scientists can actually use to make decisions. So a big part of their job is not just figuring out how to pick the data out of this and turn it into, whatever analytical structure that drives information, but also how to convey it in a way that people can actually understand and pick up and move forward with. And this, I think, is a critical part of driving our policy approach as well. Now, it's important that it's not the only part. Like, that civil society engagement comes in, working with local or domestic governments or international or multilateral partners is really important. And understanding capacity is also part of that. But you were talking about soft law, hard law, data. I don't think there's one of these that is the right fit. It's absolutely this mix of elements of information and approaches that can help us drive towards a prevention-based style. And I think you have to approach it with humility, because we're making it up as we go along. Like, there is no clear right answer here. So that's I think our approach.
Shala, let's move back to you because you mentioned briefly some comments about screening, which seems to be in this vein. So what do you think about the important tools in your area to accomplish prevention?
Yeah, no, I thank you. I would say that, I mean, in this field, and I think it's similar, Remy is in this field, I think very, very deeply. He's been in this for 15 years. Yeah, there's been a lot of development within the soft law. In terms of screening as well, we have the Equator Principles, the UN Guiding Principles on Business and Human Rights, the due diligence guidance for the extractive sector, about meaningful stakeholder engagement in that field, principles for responsible investment. So a lot of this is sort of driven by, civil society and is sort of self-regulatory in nature, but is increasingly being incorporated. And I think that's really wonderful. Within the multilateral development banks, there is this incorporation into the frameworks for environmental social governance, and the selection of projects, and the way that communities are engaged. And I think Remy did a great job describing that 3-phase approach. And I think that you see shared knowledge sharing among these banks, which is very, I think, fruitful. It's an area where you see both within sort of Western-based or Asian-based, there's this kind of convergence that these are essential tools when dealing with major projects in a community. I would say that where there's room for development is at the national bank level, where they're not bound by these same standards. That's where there's a lot of space for continued sort of rigor in terms of implementing some of these similar principles.
Okay, great. And Remy, why don't you jump in here since Shala already referred back to your work in this area.
Sure, thank you. Yes, I thought I would spend a moment to describe the legal framework that's applicable to this due diligence and harm prevention of the World Bank and its member countries. Yes, it's true, a lot of emphasis is on data collection and information gathering, but it's important to understand where those legal obligations arise. And so we have to keep in mind the distinction between the legal obligations of the World Bank, where you can think of another international financial institution, and the legal obligations of the borrowing countries, the member states. They converge in some sense, but they have distinct sources. So for the World Bank, the foundations of the legal obligations of the World Bank are the Articles of Agreement. That's the founding charter of the World Bank. And so you can think of the founding charter of another international financial institution as the guidepost for everything it does. So that's where we find the development mandate of the World Bank, and you can infer from that mandate and obligations to avoid harm or seek to promote sustainable development. There's also an obligation baked into the Articles of Agreement of the World Bank to make sure that the funds of the institutions and the proceeds are only used for the purposes for which the loans was granted, with due considerations for economy and efficiency. So that's where you find, in some sense, the requirement to conduct some due diligence, broadly speaking. And based on that, the World Bank and the board of directors of the World Bank representing the member states have adopted policies that seek to put in practice this due diligence concept. And so that's where we find the environmental and social framework that I referred to earlier from 2018. Before that, we had safeguard policies that were a couple decades older, but that is where we find an obligation of the World Bank to conduct due diligence in the project that it finances, and where we find 10 standards, I alluded to those earlier, that then become obligations of the borrowing country when they sign up for a loan from the World Bank. So practically speaking, what this means is the borrowing country signs a financing agreement with the World Bank, contract of sorts, which is really a treaty between the member state and the World Bank, that requires the borrowing country to abide by those 10 environmental and social standards. And that's a general obligations to follow the 10 standards. And in addition, for each project, and Wes made this point earlier, there's a context-specific assessment of the risks of that project, which country, which region, which communities, which areas are likely to be the subject of harm or potential adverse impacts. And based on that, the World Bank and the borrower agree on an environmental and social commitment plan. That's a specific roadmap of of actions that the borrower will take, commitments that are project specific, very practical. It's a table of commitments saying, you know, who will do what, when, on what time frame with regard to this project. And that's where we get into the development of specific assessments for particular regions or particular project activities, the development of specific mitigation plans. We have things like, you know, a labor management procedure to assess the impacts of the project on project workers, making sure project workers are adequately protected through occupational health and safety measures, or a biodiversity management plan might be developed if there's a potential risk of adverse impacts on an ecologically sensitive area around the project. Those are some of the tools that we use in our operations. A key concept I wanted to mention as well is the idea of the mitigation hierarchy. And this is found in the environmental and social framework. It actually finds its roots in the environmental and social impact assessment community of practice. So that's actually less an international law concept and more of a national law concept. Most countries around the world have environmental impact assessment laws that require the development of an assessment before a project will be approved and an environmental license will be granted. And the mitigation hierarchy requires that the adverse impacts of a proposed project be avoided to the extent possible. And if avoidance is not possible, then minimize or reduce the risk impacts of those projects. And if those, once they are minimized, those impacts are then mitigated. And if there are any significant residual impacts, the concept of mitigation hierarchy calls for a compensation or offsetting of whatever residual impacts might remain. So we find that, you know, embedded in the environmental and social framework of the World Bank. And more broadly, the concept of avoidance or prevention of harm appears over 100 times in the policy. So if you go through it, you'll see there are context-specific references to those terms for the types of harms that I mentioned earlier. I'll put the reference to the ESF in the chat for those who are interested.
So it sounds like prevention of harms forces, I think this picks up on a point Wes made earlier too, forces lawyers to live in this mixed law policy space, right? Where the structure is legal obligations, but then there's a demand to really be sensitive to how these legal obligations are translating to facts on the ground, which of course is mediated through policy. And we've talked for some decades now in the human rights space about indicators as a way to assess whether human rights substantive obligations are being followed. But it sounds like indicators are also really important in the prevention space as well. Fiona. You're on mute. Yeah.
Sorry. When you're talking about, I mean, tools, I suppose you have the sanctions themselves, and then you have the retooling of the sanctions, which of course happens annually, and the discussions around that and the decisions. And in some cases, the benchmarks that are set for a particular member state to reach, which, you know, if they're accomplished, might, you know, result in the lightening of the embargo and the lightening of the different sanctions regime. So all of that, you know, is a little bit of a kind of a carrot and stick in terms of sort of the tools available. And of course, you know, the sanctions, UN sanctions themselves derive from Security Council resolutions, which place, you know, the nation states, member states under a set of responsibilities. So it is a relatively hard law tool, but without monitoring, and this goes back to kind of what Wes was saying and also Remy, without monitoring and without information gathered by the panels of experts, you know, how effective are these sanctions as they are articulated without the fear that you're going to get caught not complying with them? And, you know, we can also point to many instances where there isn't sufficient fear of being caught, where, you know, we have these blatant and repeated violations of sanctions regimes. But I think you really do need the generation of those reports, which places very, very detailed information about violations, and not just about violations, but about the country context also, and how it's evolving and how that context is evolving, that are placed in the public domain. And without those reports, I really don't know, how effective sanctions on themselves are in preventing or even mitigating the types of violations that they're seeking to. And of course, you do have other reporting mechanisms, and you have everything that you have provided from media, from different human rights organizations or different research organizations in the conflict space. You have the Secretary General reports, you have the OHCHR reports, but panel reports are very different. And in fact, because panel members are not UN staffers, and because they are independent, because of the very nature of the way that they move, which is very different to how a UN staff person with all of the restrictions of the organization moves, the information is different. And without that, and without being able to protect those individuals to some level in order to be able to move, to take those risks, which are inherently part of the job, I'm not sure if you're going to have the same, ability to prevent through that fear of being caught, simply.
Great. So let's take a bit of a pivot here. We had a fantastic question from the audience from Mark Pollock. Hello, Mark. And he's taking us on a pivot from this realm of policy we've been in for a while now back to core principles of law. So we talked earlier in this conversation about the fact that compliance has been a big focus of international legal theorists and practitioners, theories of law and so forth. What about prevention? Where do we see prevention in core principles of treaty law or customary international law in the framework of international law that we have today? Where do we see the guidance to engage in prevention arising? And Mark mentioned the precautionary principle in international environmental law, which is a great principle. What other instances do you see in international law that really guide us to take this focus? Remy, go for it.
Thanks, MJ. A great question, Mark. I can talk about that a little bit from the perspective of the World Bank's work. Again, keep in mind the distinction I made earlier between the obligations of the World Bank as an institution and the obligations of its member countries, member states. But I do think that there's a basis in international law for that concept of prevention, and certainly a significant part of it is found in international environmental law. You alluded to the principle of the precautionary principle in international environmental law. I think that's a good reference, but there are other sources I can think of. So think about the three prongs that I alluded to earlier around due diligence, information disclosure, and opportunity to raise grievances. We find some elements of all three of those in international law. For example, the concept of civil society disclosure and consultations and opportunity to raise grievances features prominently in what we call the Access Rights Convention, like the Aarhus Convention in Europe and the Escazú Agreement in Latin America, which provide a right of citizens to be informed of projects, policies that may impact their environment. It gives those citizens an opportunity to take part in environmental decision-making and seek redress before courts or otherwise for harm that they may suffer as a result of those policies. So those conventions have those core principles that the World Bank and others in their policies try to mirror or are reflective of good practice that are adopted by these multilateral development banks, even if the conventions themselves would not directly apply to those institutions because the World Bank is not a party to them. However, the member countries of the World Bank, many of them are parties to those conventions and seek to comply with those obligations. And the policy of the World Bank, the ESF, acknowledges that by requiring, as part of the due diligence that we have to conduct, to ensure that we take into account obligations that the member country may have under international conventions that are directly applicable to the project. So you have, those conventions on human rights and access rights. The core international environmental conventions, or MEAs, multilateral environmental agreements, also embed for many of them those concepts of prevention. The Ramsar Convention, for example, calls for compensation for any loss of protected wetland resources that a member country may face. That recalls or echoes the concept of the mitigation hierarchy I alluded to earlier. The Espoo Convention requires parties to take appropriate and effective measures to, quote, prevent, reduce, and control significant adverse transboundary environmental impact from proposed project activities. And then just the final example in the realm of customary international law, the International Court of Justice has recognized in 2010 in the Pulp Mills decision that there is such a thing as a customary international law obligation of a state to use all the means at its disposal, quote, in order to avoid activities which may take place in its territory or an area under its jurisdiction, causing significant damage to the environment of another state. And it also recognized a customary international law obligation in those circumstances to conduct an environmental impact assessment for those possible transboundary impacts. So I do think there's a basis in international law that's quite relevant to our discussion today.
Great. Who else would like to weigh in on this one? This seems ready-made for you, Fiona, but Wes, go ahead.
Yeah, so I think in some ways I've actually got this a little bit easier in terms of the Genocide Convention, as I mentioned, has prevention in the actual official title. It's in there. It is interesting to note that Raphael Lemkin, the person who coined the term genocide himself, wasn't quite sure how prevention would actually work. Like, some of his statements are very clear in the fact that he wanted this to be part of it, but he didn't know how it would actually be achieved in international law. That said, the international legal principles that came along out of the UN system and parallel to it, both in the international human rights law and the international humanitarian law frameworks, are clearly designed around prevention as well as punishment and prescriptive. And so I think there is at least within the frame I work, and Remy, I felt very akin on a lot of the things you were talking about how we think about this in our approach. There is this idea that it is not just enough to say, this is a bad thing, don't do it, and we will punish you if you do, but to take affirmative action somewhere between those two things and say, we need to prevent these things from occurring. Now, how we go about that, I think international law has been quite happy to not develop that because it's difficult as a conceptual framework, especially in common law countries. Domestic law doesn't look at prevention as part of its obligation in the same way. It's very iffy if you start talking about preventing things under legal frameworks at the domestic level. And so I think international law has kind of been like, oh, this is not how we should approach this. We should focus on the prescriptive or the punitive. But I think there's a clear point to actually get to prevention as a responsibility under international law. And my, principles, my legal standards are very clearly in that. The ICCPR, the ICESCR, the Geneva Conventions, the Genocide Convention, et cetera. Like, those are prescriptive for me of requiring prevention as an objective.
Excellent. Fiona or Shala, do you want to add to that? Yes, go ahead, Shala.
Yeah, just to add another sort of example of a convention or hard law is the ILO 169, the free prior informed consent standard, which really, I think, crystallizes this idea that consent needs to be obtained, in high-risk projects or damaging projects or projects which require relocation. So, there are a handful of countries that have signed on, but it is a convention which does crystallize this requirement of consent. And I think also this, on the basis of full information about a project.
Fiona.
Yeah, I mean, obviously the UN resolutions that form the basis of these sanctions regimes are adopted by the Security Council acting under Chapter 7 of the Charter in accordance with Article 25 of the Charter. So you really have that. And then within each of the different resolutions, and they're very complicated and quite convoluted sometimes to read, they point to and recall all of the many different areas of human rights law, humanitarian law, pointing to all of these different conventions and even bringing in also, treaties that you might, that some might not think of when you conceive of the different sanctions regimes. So, for example, I was the arms expert on the panel of experts for Central African Republic, and would frequently also, and it was referred to within the resolution, rely on the particular obligations under the Arms Trade Treaty in my ability to trace and track weapons and ammunition that had been collected in the field, and reminding different member states of their reporting obligations and their obligations to be transparent with us and be reporting back on weapons and ammunition that have been manufactured within their countries. I mean, the other thing is that you are under the challenge that you're reliant on member states to implement the different provisions of these resolutions. And so, for example, as I mentioned before, you're often also talking about individuals and entities, but in fact, those individuals and entities aren't bound by the resolution. You're relying on the particular member states where they are resident or what they pass through when you're talking about the travel ban to implement those sanctions on those individuals and entities. And that frequently proves to be a weak point. But yeah, I could go on, but I'll stop there.
Great. So just a reminder to the audience, we have about 12 minutes left. So if you do want to have a question, please don't hesitate to drop it in the Q&A box. So, another reading perhaps of the entire UN Charter and the entire UN system and all the law that came after World War II is that the entire structure of modern or post-World War II international law is designed at prevention, right? Preventing more use of force, preventing another world war, resolving disputes in a more productive fashion than war, right? So in a way, perhaps prevention is the core principle of international law, and maybe the discussion should then shift to what are the best ways to prevent disorder, right? To prevent force or prevent other disordered uses of power. So I guess thinking of it as prevention as the kind of core principle of international law, from your perspective in your area, what do you think about the potential of international law and international legal institutions and organizations to successfully engage in harm prevention? Clearly, we can point to the big examples. We have, we have violence and war happening in various places that suggests we're not super successful at preventing resort to use of force. But you have much more specific areas that you're working in, and how is the outlook from where you stand in terms of the potential of international law to engage preventatively in dispute resolution? Or not even dispute resolution, but preventing various kinds of harms.
Why don't I go first on this one to get the bad news out of the way? But MJ, I love that formulation of this, like looking at the post-UN framework as prevention is actually the core central tenet of this. I love that. I think it's absolutely the kind of thing that international legal scholars and practitioners should be picking up and saying, okay, what does it mean if we actually approach the world that way? In terms of, do I think that there's a path forward, an effective path forward in the international legal institutions and instruments? I'm not as optimistic about that as I am about domestic states taking the lead on trying to move these things forward. I think the structure of the UN, with the emphasis upon sovereignty of its individual actors, and the emphasis that the only actors that it relates to are states, means that this particular area of atrocity prevention, genocide, war crimes, crimes against humanity, it is really difficult to move forward. Literally just yesterday, Just Security put out the first piece in a series on the future of atrocity prevention, and Alex Bellamy of the Asia Center for the Responsibility to Protect did a wonderful piece on kind of the difficulty of politics within the international legal and institutional structures, and I'll put the link in the chat. But it's a phenomenal piece. It's not a positive, upbeat piece, but I think there are significant political barriers to pursuing the international legal objectives of prevention in this context. And so, yeah, that's a challenging path forward for us. It's why I think working bilaterally and multilaterally outside of perhaps some of the UN structures is just as important as trying to continue to push forward in the UN framework. Like, I'm not saying we don't work within the UN system, but we've got to do more than just that, because the international legal norms and institutions have made clear that this is not a priority for them.
Okay. So other comments on the potential of international law? Go ahead, Fiona.
Just really just to jump in and to bounce off of that point, just very well made, which is that, I mean, we all know the reality. I think the way that you framed it is very nice. And we came out of this moment seeking to prevent, came out of World War II seeking to prevent that kind of event ever happening again. I think, unfortunately, we are at a place in terms of, international law is informed by international relations, and we're at a place of strain in the global system, that the ability to have the consensus in order to truly enforce whatever instrument we're talking about within international law in order to truly have a preventive capacity is really in a difficult place right now. And I mean, this is speaking to the very, very small and very practical component of being a member of the panels of experts, as I referred to, that is really, really under threat and really, really in a complicated place. And I think specifically in order for those bodies to move forward in an effective way, they need to be retooled. I think the likelihood that that's going to be gotten to in terms of practically within all of the many committees of the UN being a priority is so low on the totem pole. But yeah, overall, I'm afraid I don't have a particularly rosy answer for that.
Go ahead, Remy.
Thanks. Maybe on a more optimistic note from the multilateral development bank perspective, I do see some positive developments. Charlotte earlier referred to a number of soft law instruments that have developed. I think there has been renewed focus and attention on how best to conduct due diligence and prevent harm with regard to projects, investment projects. And that is an area that is continuing to blossom. And I do think that multilateral development banks, private banks, government actors are trying to adopt that good international practice to the extent possible. And there's more to learn, more we can improve, but I think it's trending in the right direction. We also have an opportunity through our work to put in practice some of these broad principles of prevention. So we alluded to some sources of international law earlier and the policies and procedures of multilateral development banks, but we do this work very practically every day. And so we do try to, in a very real way in which harm occurs in projects, prevent that harm, mitigate that harm, compensate for that harm. And I think that is also headed, in the right direction with learning and improvements in policies and practices over time. The ESF in 2018 is an enhancement over the previous safeguard policies of the World Bank from the 90s. The ESF is continuing to be refined in its implementation, strengthened in various ways. So I do think that is also a positive development. And then finally, another role that multilateral development banks can play is to strengthen, and they do play, is strengthening national capacity and legal frameworks around these issues with our member countries. So the World Bank, through the project and finances, and also in its technical advisor capacity, strengthens national legislation, including environmental and social impact legislation at the national level that has a tremendous impact in preventing harm from projects that will be financed from international sources or domestic sources. So that's also, I think, a positive development.
Sure, Charlotte.
Yeah, so I guess just to address your question about sort of the direction or how can we improve the tools, I think many of these instruments that we talked about, both hard law and soft law, they refer to consultation, but this is, I think, an important area of learning. What do we mean by consultation? And I think Wes and others mentioned so much is context specific, and consultation really has this potential to lead and guide discourse, and through appropriate channels, through full participation. So how we nurture that, how we understand that, I think that's an area of learning. And I think the more we can sort of share and focus our attention on that, I think the better these instruments will be, and the more effective they'll be. And I also just noticed Anne Trebilcock mentioned the ILO had other provisions also. I just point that out for safety and health. And I saw that she was involved in the writing of ILO convention. So thank you, Anne.
Fantastic. So we're down to the last couple minutes here. So let me pick up on something you just said, Shala, for a lightning round. What can international law or international legal institutions do better to better address prevention? And Shala, you just mentioned consultation and participation as sort of a key principle to think about going forward. And so you can leave it there, or you could add on if you have another idea. But lightning round, one thought each of you has on how we could do prevention better.
I think mine is simply talking about it, like actually engaging with this and saying, we acknowledge this is a responsibility of the international legal framework and of international organizations, that prevention is not just this pie in the sky, idealistic kind of thing. No, it's a core fundamental requirement of how we approach our obligations under international law, would go a long way.
Yeah, I think I'll just chime in with documentation.
Maybe my suggestion would be specialized in context-specific discussions and tools. It's true that prevention is a norm that is relevant across the practice areas of international law and fields, but once we get down to specifics, it really comes down to sector-specific issues, institutional context, particular regions, countries. And so encouraging very focused discussions by practitioners in particular countries or particular contexts is helpful, and the particular tools and issues that they face will get us to very practical answers and good practices.
Okay, so acknowledgement, documentation, consultation and participation, and specificity. All right, great. So thank you very much to all the panelists for this really rich discussion today. Thank you to all the attendees, and a particular thanks to the organizers from the International Organizations Interest Group, Duncan Picard, Christian Corte, and Desiree Leclerc. Thank you very much to everyone.
Thank you.
Thank you.